On behalf of the state.
Thank you, Your Honor. May it please the Court, Judge McIntosh, Mr. Thomas, Ms. Dixon. Ladies and gentlemen of the jury, as I sat there and listened to Mr. Thomas, I wondered if he was in this same courtroom as me for the last 2 weeks. He said the state's case is based on speculation, and he asked you to set aside any bias or sympathy. The state doesn't want you to decide this case based on those gruesome, horrible, terrible photographs that we had to show you. We want you to base your decision on the cold, hard facts. Apparently, Mr. Thomas is willing to say that Detective Hal's geolocation evidence is okay when it puts him at the Fine Fair Food Mart. That it's okay when it puts him at the BP. That it's okay when it puts him at the BP. It's okay as he is going out Main Street and Livingston Avenue within the hour of the murder of Rachel. He wants you to think that when we see his photograph just down the street here at the Rife Tower, and at the same time, guess what? His phone's there, that all those geolocation evidence is sufficient to show he's using the credit card, he's with his sister. But on the night of the murder, well, let's just disregard that geolocation evidence. That doesn't fill in a gap. That doesn't complete the puzzle. I guess, again, as I sat there, I thought, well, about the only thing that would satisfy Mr. Thomas is if Rachael Anderson walked in here and raised her right hand and told us who did that terrible thing to her. Because Judge McIntosh would tell you that our burden is beyond a reasonable doubt, and I think we talked about it with some of you in voir dire, that it's not beyond a shadow of a doubt or beyond all doubt. Judge McIntosh would tell you our burden is reasonable doubt is something based on reason and common sense. It's not mere possible doubt. And everything Mr. Thomas said was raising a mere possible doubt, but it's a doubt that is relating to human affairs or depending on moral evidence. Everything's subject to an imaginary doubt. And Mr. Thomas gave you a parade of imaginary doubts. First, I think, he said that Detective Hughes stopped the investigation as soon as the defendant's DNA was found. That's not true. You know it's not true. Because what did they do? And he's indirectly, I think, pointing the finger in one way or another at John Kennedy. They went out and got a swab from John Kennedy. They sent John Kennedy's DNA to the crime lab. And the criminalist here yesterday said, John Kennedy's DNA ain't on the curling iron. John Kennedy's DNA ain't on the hair dryer. John Kennedy's DNA, most importantly, isn't on the inner thigh, the vaginal area, or in the vagina itself. John Kennedy didn't kill this woman, as apparently Mr. Thomas seems to suggest. The cold hard facts show his phone at every place within the hour, the next day, and the following day. And most importantly, who tells you, besides the phone, that he was there? His own sister says, yes, that's me at the DSW. Yes, that's Anthony wearing the hat he wears every day, the red and black New York hat. That's Anthony there. We know it's Anthony there. We know he's at DSW. We know he's with Deborah at Northern Light Shopping Center. That geolocation works when Mr. Thomas wants to say he just used a credit card, but apparently it doesn't work in his mind the night of the murder that puts his phone there. And as I recollect Detective Hal testifying, at one point it was within 20 meters. There were 35 hits, as Ms. Van Kulen said, over that hour and a half, from Wi-Fi, from cell towers, from the GPS, 3 separate ways that put that phone in Rachael Anderson's apartment. Then we have the use of the credit card. Those cold hard facts showing that he's where he shouldn't be in the apartment at the time of the murder. He's there with his sister. He's there with Mr. Sleets. One thing he talked about, and I made a note, was what about Rachel's car being driven over there to the R&M Food Mart? And what about it being driven back? Where's the phone information on that? As I recollect that Jennifer Lester, the BCI agent, who also did some phone and location things, testified there was no activity on the defendant's phone during that time frame. And as I recollect, she said the phone's turned off, that you won't have those 3 things working on the phone: the GPS and the Wi-Fi and the cell tower bouncing or pinging, as I think was the technical term. So if the phone was off, then that would account for that. And we don't know. We do know that the car was taken from the home. We do know the keys were missing that had never recovered. Keys on the lanyard were missing, with the car keys, with the house key, and the house was locked the next day. As we go through these different things, Mr. Thomas also said that there was no witness that walked in this courtroom, raised their right hand, and said that Anthony was in the apartment. Well, even though she didn't testify, Rachael Anderson tells us he was there, because his DNA is in her vagina, the vaginal swabs. Dr. Daniels, yesterday afternoon, Ms. Roush, when she talked to him, said, now, were those vaginal swabs taken before or after the autopsy? He said, no, the vaginal swabs were taken before the autopsy. And a vaginal swab, Mr. Thomas seems to suggest, is something other than a vaginal swab. A vaginal swab is a swabbing of the vagina to see if there's foreign evidence, be it saliva, be it blood, be it semen, in the vaginal area. That supports the rape. Judge McIntosh will tell you, and at least in some of the questioning, and then here again this morning, the definition of sexual conduct, which is what is rape by force, is having sexual conduct by force or against the victim's will, that penetration, however slight, by any body part or item constitutes penetration. The defendant could have stuck his finger into the vagina, and it would leave those skin cells that we heard about. The defendant could have stuck his penis in there as well and not ejaculated. And if ejaculated, there may not have been sperm in the ejaculation. All those things happen. All we do know is through a finger, through a penis, through an ejaculate, one way or another, that man sitting right there in this courtroom, his DNA is in her vagina. And it's not only just in her vagina, it's on her thigh, on the inner area, and it's on the bindings that bound the woman. Talking about the swabs that Agent Durst took, and then the criminalist from the crime lab also took, I think there was a question when Mr. Durst testified, did you swab the whole length of that cord? Again, presumably to suggest somebody else's DNA may have been on there. And he said, no, I just swabbed around the bindings. Yesterday, the scientist from the CPD crime lab said, I swabbed the whole thing, the length of that. Also, the item itself. And by the way, why would the defendant's DNA be on it at any location, be it on the handle, be it on any part of that 4, 5, 6 foot cord. His DNA is there. I didn't hear the word plant, but Mr. Thomas came pretty close to saying somehow that his DNA was planted in the vagina. It was planted somehow on these cords. I mean, how else would it get there other than he was there? He touched those cords, those terrible cords that bound Rachael Anderson's legs and wrists. And we heard that DNA can be lifted more easily off certain items than others. The defendant had some gloves in that car. Mr. Thomas talked about, well, there were no fingerprints. There were no fingerprints in the car. We know that Anthony was in the car, and we see him get out and go in and use the car, who testified via the videotape. So we know he was in the car. We saw him get out. His fingerprints aren't there. His DNA's not there. You can be in some places and not find those things. So when Mr. Thomas says that there's no fingerprints, well, we have gloves and we also have fingerprints aren't always left, as the experts said. If there's any speculation in this evidence, ladies and gentlemen, it's by Mr. Thomas in suggesting that the state hasn't presented a strong, powerful case. There was investigation after February 6th and February 8th. The other DNA was collected. Tons, I might add, of phone records were collected. The phone records would speak for themselves, be they Miss Rachael Anderson's, whether they're John Kennedy's. I think Deborah Pardon, her DNA was obtained. Since she was using the credit card, was she there in the apartment? No, no DNA of Deborah Pardon there. No fingerprints of Deborah Pardon there. Her DNA was sought, examined, and the experts tell us it wasn't there. So when Mr. Thomas wants to suggest everything stopped on February 6th and Detective Hughes wanted to just build a case on the defendant, that's not at all true. Records were sought up until sometime the middle part of 2019, we heard. Detective Hughes worked on the case after Detective Welsh got off of it. His alibi. I don't know how else you check an alibi other than saying, who were you with, and talking to that person and they confirm it. John Kennedy's phone wasn't down there. John Kennedy's DNA wasn't down there. So any suggestion that he somehow is complicit is just speculation and, I might add, quote, imaginary doubt that Mr. Thomas is planting with you based on this evidence. Remember, Detective Hughes said, and I'm trying to go through a checklist here, the state has a burden of proof, so we have an opportunity to what they call rebuttal. And that is, I'm trying to hit the points that Mr. Thomas raised that, in my view, were quote-unquote imaginary doubt. And one of those was he said there was no video of the man that went in the store that gave Mr. Sleets the credit card, which, surprisingly, as I recollect, Detective Hughes said, we didn't identify someone until several days later. We went and we got certain information from the people at the first location, but when we went back, they erased it. They're on an auto erase every certain amount of time so that they don't have to keep using and buying new recording items. And so Detective Hughes again tried to find that. He tried to find Mr. Sleet. I think he said he put a hold on him. And sometimes he puts a hold on somebody and they're out for a year and a half before they find somebody. He went back to the same location, he said, to try and find Mr. Sleets. And he was unable to do so, then found out Mr. Sleets was dead, and at least he was able to testify from the grave through his video statement. Rachael Anderson wasn't, was she? when he talked about the robbery, no evidence of robbery, no evidence of the burglary, well, the way she was bound and gagged, raped, hogtied, and murdered, he would want you to think that she invited the person that did that into the house and that they didn't trespass by forced stealth or deception. We know it's not forcible entry. But he certainly was in that apartment within 20 meters from 7:59 to 9:25, and about 9:46 or 49, that credit card was used not far from that location. And then over the next several days, it was used. The evidence of rape is shown, the state submits, by the DNA evidence, for which there's no other explanation. The robbery is shown by a theft offense, removing the credit card from the premises and using it. That's a theft of the amounts, whether it's $100, $200, whether it's purchasing shoes at City Trends, whether it's buying shoes up at Easton. Those are all theft offenses that were part and parcel of the crime that happened on the 28th. The state submits, ladies and gentlemen, that what Mr. Thomas has done is plant at different stages so-called imaginary doubts. Because this case, on that date, January 28th, on her 24th birthday, Rachael Anderson in her apartment with her Arby's food bought at 7:30, lighting a candle, putting her birthday cake on the counter in the kitchen. Someone took her from downstairs, upstairs. That's kidnapping. Someone bound her, gagged her, hogtied her. That's a restraint for purposes of committing other crimes, be it rape, robbery, or part of the burglary. Someone's DNA was in her vaginal area, and that someone sits right here. And that someone is Anthony Pardon, and ladies and gentlemen, that someone is guilty of each and every count and guilty of each and every specification. And I want to thank you for your attention throughout the trial.
Thank you, Mr. O'Brien.